So a call comes through, right? And you discover that on the other end is a telemarketer. So what do? Do you hang up or continue with the call? Whatever you do, chances are you are irritated and wondering how and where they got your number from. So this is one of the big questions, especially because the POPI Act is clear on electronic communication, but it seems there might be a loophole that some of these companies are exploiting. This is something that the Information Regulator wants to deal with, and Advocate Pansy Tlakula is the chair of the Information Regulator of South Africa. Thank you so much, Advocate Tlakula, for your time. So if the POPI Act is clear on electronic communication, so why then do we still receive calls from marketing companies?
Thank you very much for having me, and good evening. I think the problem is the interpretation of what constitutes an electronic communication in POPI, because the Act provides that an electronic communication is a message that comes through a text, a voice, an image, which is stored in the network or in the recipient, or it is stored in the device of the recipient until the recipient retrieves it. So some people say that a telephone is not stored in the network. If you receive a call, say from a call center, that call is not stored in the network. You receive the call instantly. So that is where the problem is with the interpretation of the Act as it pertains to telemarketing. So that's what we are trying to deal with as the regulator. I also have to say that we are not the only one in the world who has that definition. If you look at the General Data Protection Regulation in Europe, and you look at the Data Protection Act in the UK, their legislation have the same definition, and they have included messages received through a telephone in the definition of electronic communication. But there are countries like Canada, for instance, that have taken an opposite view to say that a message received through a telephone does not constitute telemarketing through electronic communication.
Yeah, so are they correct, though, in their interpretation, in your view?
You know, we have sought also the opinion of IT specialists, and we have received conflicting opinions. We have those that say that if you receive a call from a call center, if it's not analog, then it is an electronic communication because that message is stored. And there are those who say, who hold the opposite view to say it is not. But at the end of the day, we as the regulator will have to take a decision one way or the other. And we are very close to taking that decision because we are in the process of finalizing a direct marketing guidance note that will guide the direct marketing sector on how to deal with direct marketing in compliance with POPI. And in that guidance note, we'll have to take a decision once and for all to say, where do we locate telephones, particularly because they are such an irritant to South Africans.
I don't envy you when you have to take that particular decision, but how soon can we then expect to get this direct marketing guidance note?
We are finalizing it this week, but we don't want to adopt it on our own. We want to subject it to public consultation. We also want to consult the direct marketing sector. But at the end of the day, we'll take a decision. And whoever doesn't like that decision, one way or the other, may approach the court, and maybe the courts in this country will assist us to interpret POPI in this regard.
So there are concerns, you know, sometimes we often hear of people saying that there are companies that are selling the database to some of these companies, and that's how they're then getting to have our numbers, because we always wonder, where are they getting our numbers from? So is this the truth?
Yes, there are data brokers out there, and we are actually, one of the investigations that we are conducting is against people who sell personal information of others. So that is true. So even if we come to the conclusion that a telephone does not constitute an electronic communication, that does not mean that telemarketers can go and buy our personal information and use it. The law is very clear. They have to obtain our contact details lawfully, unless, of course, the data subject has made the personal information deliberately public, or if the personal information is contained in a public record. So those are the only exceptions. But I think South Africans are only looking at telephones. Most of the people are also getting messages through SMSs and through emails. I'm talking about direct marketing messages. And the law is very clear. What has to happen is that a company that wants to send you direct marketing messages, say through an SMS, their first SMS communication to you must be the one in which they request your consent for them to send direct marketing messages to you. You must consent, and you must also consent on the type of communication that they should use to market their goods or services. You can say, okay, contact me through SMS or through email. That's the first message that they should be sending. Only after you have consented can they then send direct marketing messages to you. If you say no, then a company has to have a database of all the people who have said no, so that they ensure that they don't contact them again. And I don't think this happens, because you know that people change. Sometimes they use this kind of communication. They can use SMS, next time they use email, and those SMSs, they already market goods to you and they say opt out or unsubscribe. That's very wrong, because the first communication has to be the one in which they request your consent that they can send you direct messaging,
And
direct marketing.
there's something else, though, very briefly as we end off then, where you block one number and then they can call you using a different number, and they can use 10 different numbers with one different service. So how is that the fault of service providers who are providing them with these numbers, or what's happening there?
No, just breaking the law and taking advantage of the fact that no one has been, no action has been taken. But we are in the process now of finalizing a complaint, and we'll be issuing an enforcement notice. But this enforcement notice is in respect of direct marketing messages that were sent through email, and the complainant had asked the company to stop, but they kept on bombarding and bombarding. So because of the electronic communication definition, as I said, direct marketers are taking advantage. But as I say, once we issue the guidance, then we'll see the end of this, hopefully.
I honestly cannot wait. I'm one of those who can't wait for this direct marketing guidance note. So we'll wait for it and see what is contained in it. But thank you so much for that update and for just giving us a sense that something is being done about this. That is Advocate Pansy Tlakula, Chair of the Information Regulator of South Africa.